The evolving landscape of regulatory compliance AI. Why the cure period in regulatory compliance AI is a temporary safety net, not a long-term strategy. For years, enterprise leadership has operated under a wait-and-see approach to artificial intelligence. The common assumption was that regulators would provide a long runway, a series of warnings, and ample time to pivot before issuing the first fine. However, as we cross into the second half of 2026, the era of gentle warnings is officially coming to a close. The emergence of regulatory compliance AI has moved from a theoretical corporate goal to a baseline technical requirement. Two major pieces of legislation, the EU AI Act and the newly enacted Colorado AI Act, SB 26-189, have codified exactly how much grace a company can expect. While both laws include provisions for warnings or cure periods, these are designed as temporary relief for honest mistakes, not a permanent pass for systemic negligence. The Colorado Reset, a statutory opportunity to cure. On May 14, 2026, Colorado Governor Jared Polis signed SB 26-189, effectively repealing and replacing the state's original 2024 AI framework. This reset was designed to be more business-friendly, shifting the focus from broad risk assessments to specific transparency regarding automated decision-making technology, ADMT. One of the most discussed features of this new law is the opportunity to cure. Under the statute, the Colorado Attorney General is required to provide a 60-day written notice of a violation before initiating an enforcement action. This gives firms a window to fix their disclosure or human review processes without immediate penalties. However, this is where the safety net begins to fray. The law specifies that this right to a warning sunsets on January 1, 2030. Furthermore, if a violation is deemed knowing or repeated, the Attorney General can bypass the warning and move directly to penalties of up to $20,000 per violation. For a bank processing thousands of automated decisions, a single, repeated failure in their regulatory compliance AI stack can result in a multi-million-dollar liability overnight. The EU AI Act, the global anchor for deterministic standards. Across the Atlantic, the EU AI Act remains the global technical anchor. While the AI Act Omnibus, passed in May 2026, extended the deadlines for high-risk standalone systems to December 2027, the transparency requirements for chatbots and deepfakes remain fixed for August 2, 2026. In our recent blog, The Global Gravity of the EU AI Law, we explored how this law functions as a technical mandate for U.S. banks. Unlike Colorado's statutory cure period, the EU's approach to warnings is entirely discretionary. While a regulator may issue a warning for a minor, first-time documentation error, they are empowered to move directly to administrative fines for failures in high-risk sectors, like banking and insurance. When an institution fails to provide the required meaningful human review, or point of interaction notice, the EU regulator is likely to view this as a failure of architecture rather than a simple oversight. In these cases, the warning is often the fine itself, which can reach up to 7% of global annual turnover for the most severe violations. The shift from systems to decisions. The common thread between Colorado's SB 26-189 and the EU framework is a move away from regulating the AI system, in the abstract, toward regulating the individual decision. As noted in After August 2nd, your AI chatbot is a liability. The legal risk has moved downstream. Relying on a warning in this environment is a high-stakes gamble. If your regulatory compliance AI is not built with a deterministic completion and compliance layer, you are effectively waiting for a regulator to tell you that your house is on fire. By the time the 60-day Colorado cure period or the discretionary EU warning arrives, the digital neglect has already compounded into a public-facing audit failure. Effective regulatory compliance AI must provide deterministic execution, ensuring the AI cannot bypass corporate or legal boundaries. Real-time disclosure, providing the why behind a decision at the moment of interaction. Audit-ready records, moving beyond chat logs to capture a full map of agentic accountability. Quantifying the gap, the CoDN metric. The financial danger of waiting for a warning is captured in the cost of compliance digital neglect, CoDN. This metric represents the hidden liability that builds up when an enterprise scales AI without a structural governance layer. In a 2026 landscape where the cure period is sunsetting and EU transparency mandates are active, your CoDN is your most significant unmanaged risk. Adhering to legacy frameworks like SR 11-7 or waiting for an attorney general's letter is no longer a viable defense. Innovation is only an asset if it is defensible from the first interaction. Stop guessing and start quantifying. Use our specialized engine to run the numbers for your industry, identify your specific exposure, and calculate your cost of compliance digital neglect. CoDN today. CoDN.callvu.com